touch my hand, it's gone. Touch my hand, it's gone. Touch my hand, it's gone. I told the blood once to touch my hand, it's gone. 10 toes, only thing I'm standing on. This bitch wanna fuck me, she like standing home. She ain't all in one way, she keep playing on the phone. That touchdown, woo, wrapped in saran. Said it was a trip, but they had it again. I ain't benefit the way kids stand. This young bitch gon' give me top. She not loyal, stick on this alone. This shit can't spoil. I got this prices up and down. This shit's like oil. The place your oil. Poppy put it down and coming straight from the board.
Inside, let's go. Touchdown. Tatiana getting bust down. Got money, she won't fuck now. We ain't fucking, bitch, I'm up now. I'm high. Sitting swinging with the guys on the wrong side of town. Threw a flaggy offside. Come to the eat you, gon' die. I'm daddy. Mix a perk with the Henny. I got a Big Mac on me. I'm Diddy. Shooter never losing touch. Hey, pass trade glitch. We gon' spin until we bitch. Double back if we miss him. Drop the addy, we gon' kill him. Yeah, cook him, grill him, light it up, hurry, spicy, curry, wrist, McFlurry. I seen him, he worried. I got the deuce, let's pour up. I'm fucking mamas and daughters. Yeah, I got water on water. See it out, we get on that. Stop him out, he a floor man. In his pockets, I want all that. Heard you was pussy, it's soft that. And y'all slide, we ain't on that. Nah, they kill my man, we kill his cousin, we get that point back. Yeah, so.
Touch my hand, it's gone. 10 toes, only thing I'm standing on. This bitch wanna fuck me.
One more.
Where's all the fathers at? Why these young boys gunning each other down in the street? Where's all the uncles at? Why these young boys is gunning each other down in the street? Where's all the gangsters at? Where's the OGs at? All you dudes that claim all this OG shit. What is the purpose of talking about how much of an OG, how much of a gangster you are when you cannot stop these babies from killing babies?
That boy is Benny Hines.
Fuck all your chitter chatter. Black lives don't matter. Kill each other for the master. Disappear like abracadabra. They eat, get fatter. Recipe of the disaster. Bullets fly, niggas scatter. Black lives don't matter. Fuck all your chitter chatter. Black lives don't matter. Kill each other for the master. Disappear like abracadabra. They eat, get fatter. Recipe of the disaster. Bullets fly, niggas scatter. Black lives don't matter. Who blicky or choke. Shit don't matter to parole. I was gang, never gang bang. I was all about the dough. The big homie, he was slow. I was always on the go. They was jealous of the flow. The assist messy fucking all of the pros. Ho. Poor shame to the set. They only fade through sex. And fucking with the big jacks. Bitches getting faded, give a neck, then move to the next set. That's why we can't get respect. That's why we live and die in debt. Big homies keep last shit slide, niggas need chin check. They say women lie, men lie, but I ain't got no regrets. I ain't never been pressed, nigga press me, nigga get death. You even fucking with my philosophy or you playing with the rest. All that in between playing both sides, shit get niggas left. Fuck politics, niggas slip the rent, act funny, I'm direct. Breed the niggas to be less and settle it even less.
This ain't no clickbait either. This gonna be the realest stream I ever made on YouTube. Watch. I like this second verse the best. The way how he rapping, you can tell he really mean it.
Frustrated, I'm just feeling like a castrated when I'm chasing paper. Mass shooters on a black man and a MAGA hat's always in the paper. Black hatred, I don't trust you niggas cause my own kind trying to soul a nigga. Black lives don't matter to me cause my same brother trying to earth a nigga. Why nigga? Same struggle that you have, I'm trying to survive nigga. Just go and use your mind nigga. If you don't, then you die nigga. Why you moving like you suicidal or being controlled by a fucking bite? I will move on a fucking right, but I'd rather die than stand beside you. Enslaved, niggas killing just to get paid. What the court say? Enslaved, Gucci and Louis Vuitton but never got rent paid. What a trope, what the world say. We will collapse like the world trade. Catching cases off of cocaine. We contribute to the jail trade. We was never given mercy. Black lives never mattered to them.
All right, look, we gonna get right into this, right? This gonna be the realest stream I ever made on YouTube. Watch this. Get straight into it. Looking it up, the Supreme Court's use of definitions. I hope y'all see this, right? Yeah, we good. The Supreme Court's use of dictionaries and statutory and constitutional interpretation by Kevin Werbeck. This is federal documents right here, and this is all rights reserved, but I'm saying fair use like everybody else love to say on YouTube. This is for purposes of education and criticism. I'm not taking this trying to make nothing off of this. Almost 50 years ago, Judge Leonard Hand declared that it is one of the surest indexes of a mature and developed jurisprudence not to make a fortress out of the dictionary. 1. Despite this admonition, courts have long used dictionaries to aid their interpretive endeavors. Dictionaries are, after all, reference books that help readers comprehend the meanings and boundaries of words, which is precisely the function judges most often perform. The Supreme Court, too, has referred to dictionaries in more than 600 cases over a period of 2 centuries. 3. In recent years, however, the court has come to rely on dictionaries to an unprecedented degree, despite the current resurgence of interest in statutory interpretation among legal scholars. 4. And the increasingly vocal debate. 5. About judicial methodologies. The use of dictionaries as interpretive tools has received little scrutiny. Y'all make sure y'all hit that Cash App up. $ Devon Bay. Hit that Cash App up. $ Devon Bay. And go subscribe to this channel and all my other channels that y'all see out there. If y'all see my face and you see me live putting out the content, that's my channel. If you see slander, that's not me. This paper argues that the Supreme Court should exercise greater sensitivity in its use of dictionaries. Part 1 demonstrates the increased prominence of dictionaries in Supreme Court opinions during the last several years. This shift is too substantial to ignore or dismiss as a coincidence. Some underlying factors must explain the trend. Part 2 therefore situates the court's use of dictionaries within a broader context of changed attitudes towards statutory interpretation and the role of judges. Dictionaries are not ideal tools. They provide a range of definitions that bear an imperfect relationship to context and meaning. This ain't no clout chasing right here. That's what I'm telling y'all. This is going to be the realest stream you ever seen on YouTube. The context of the dictionary as an interpretive tool requires substantive decisions by judges and introduces the antecedent assumptions of dictionary editors into the legal process. Part 3 suggests that these and other considerations gravely limit the value of dictionaries to statutory and constitutional interpretation, and that the court's current unself-consciousness attitude towards the reference books greatly exacerbates these problems. The paper concludes in Part IV with suggestions for more rigorous and more appropriate use of dictionaries. Now, this is deep right here, right? Dictionaries have been in existence since well before the American Revolution and have appeared constantly in Supreme Court opinions since the early days of the Republic. The first English dictionary was published in 1552, and Samuel Johnson's celebrated Dictionary of the English Language was first released in 1755. The Supreme Court first referred to one of the reference books in 1785 when it acknowledged an attorney's citation to Johnson's dictionary. Although American lexicography was in its infancy, the court cited dictionaries a total of 23 times prior to the Civil War, evidently realizing the important role that dictionaries could play in legal interpretation. Noah Webster sought to have his American dictionary endorsed by the Supreme Court in 1831, but Chief Justice John Marshall rejected the offer. From the mid-19th century Through the 1970s, the court referred to dictionaries in virtually every term, but rarely more than a handful of times per year. In the quarter century between 1958 and 1983, for example, the court cited dictionaries 125 times, an average of 5 times per term, 12 prior to 1980. In fact, the word dictionary never appeared more than 15 times in a single volume of the Supreme Court Reporter. In recent years, however, the court's use of dictionaries has increased dramatically. In the 6 terms between 1987 and 1992, the court never cited dictionaries less than 15 times, with a high point of 32 references during 1992 term. I know y'all like, what does this mean? Examining the explaining the trend, a rise of planned meaning interpretation. The court's growing faith in dictionaries is tied to a broader methodological shift toward textualism and statutory interpretation. The dramatic, sustained increase in citations to dictionaries cannot be coincidental, and considerations such as the relative insecurity of some justices or the greater prevalence of statutory cases before the court are insufficient to explain the trend. A search for unitary causative factor to explain the court's increasing use of dictionaries will be both misguided and futile. This trend is undoubtedly the result of many elements. This realization should not, however, preclude an investigation of certain important factors and their significance. This paper focuses on a connection between the use of dictionaries and broader interpretive methodologies for 3 primary reasons. First, to the extent that the court justifies its use of dictionaries, it does so through arguments about modes of interpretation. Second, there exists a broad literature on statutory interpretation, which provides a useful framework in which to situate an analysis of the role and significance of dictionaries. Third, dictionaries provide a unique opening for an internal critique of certain aspects of the court's interpretive practice. Over the past decade, the Supreme Court has embraced interpretive theories that give greater emphasis to statutory texts and less significance to legislative history and other secondary aids. As the composition of the court changed during the Reagan-Bush years, justices who trumped the importance of constraining judicial activism through formalist interpretive methodologies replaced those who were willing to read statutes expansively to effectuate public policy goals. Plain or ordinary meaning interpretation, among the most significant manifestations of this new textualism, seeks to identify the import of statutory language will have to a typical lay reader. Proponents of this method argue that secondary sources should only be consulted when the ordinary meaning of a statute cannot be determined or would compel an unreasonable result in a particular case. Advocates of plain meaning, led by Justice Antonin Scalia, ground their methodology in notions of judicial restraint and democratic accountability. In his cited dissent in 1991 case of Chisholm versus Romer, Justice Scalia forcefully argued for a plain meaning approach, which he deemed the court's regular method for interpreting the meaning of language in the statute as a bulwark against judicial usurpation of legislative powers. He chastised the majority for its reliance on legislative history. Now, y'all can read that and screenshot the rest, right? Plain meaning in dictionaries. Adherents of the plain meaning approach have long assumed that dictionaries are the best source of the common understanding of words. The identifications has become so pervasive that many commentators use the terms almost interchangeably. In fact, it is difficult to find a source that explicitly justifies the use of dictionaries to determine plain meaning. The connection seems obvious after all. Where else would an average lay reader go to determine the meaning of a statutory term but the dictionary? Furthermore, dictionaries have the virtue of appearing neutral, thus gaining greater legitimacy for interpreters concerned about judicial subjectivity. Recent Supreme Court opinions, such as Justice Scalia's Chris Holmes dissent, frequently accepts as uncontroversial the underlying propositions that dictionaries reflect the ordinary meanings of terms, precisely after attacking the majority for theorizing about congressional motivations for using the term representatives in the Voting Rights Act. Justice Scalia, let's do a little more digesting. It says, look, it's not, we're going to go through that. It says, Justice Scalia Bruce brusquely announced that there is little doubt that the ordinary meaning of representatives does not include judges. His primary support for this assertion was a citation, without an actual quotation, to Webster's Second New International Dictionary. Justice Scalia apparently did not feel compelled to justify his reliance on a 40-year-old dictionary. That's how I be feeling. Like, y'all be quoting all these dead people and got websites with dictionaries with old dead men on there. Like, you pulling out a bunch of old dead people. I am the dictionaries that y'all be reading. That's why every time when I go live, it's always people gonna watch my videos. You reading me like a dictionary, you should be buying law books, reading the law books and making videos on that. But you reading me, trying to figure me out like you should be reading your children, teaching them the law. But it's all good though. See, he said Justice Scalia apparently did not feel compelled to justify his reliance on a 40-year-old dictionary, which was first published more than 3 decades before the passage of the Voting Rights Act, to ascertain the ordinary meaning of the term. The identification of dictionaries with plain meaning, it seems, was self-evident. 2 cases from last term demonstrate the various ways the court is willing to give dictionaries. Now, some dictionaries that's old got real meanings that they took out, so I don't agree with that. As sources of ordinary meaning, priority over the interpretive age in Smith versus United States, the court considered whether a defendant who offered to barter a gun for drugs had used the gun in the course of the drug purchase under a statutory penalty enhancement provision. Justice O'Connor, writing for the majority, based her construction of use on definitions from 2 dictionaries. She concluded that the term did not include the petitioner's conduct because in ordinary parlance, use means to convert to one's service or to employ. Although she concluded that language, of course, cannot be interpreted apart from context, Justice O'Connor rejected the dissent's arguments that the statute should be read in context to require the use of a gun as a firearm. She explained that even though both interpretations were acceptable, they were not exclusive and did not indicate the way the term was most reasonably read. Justice O'Connor apparently concluded that her reading of the statute was the most reasonably ordinary meaning because it fit the definition in her chosen dictionaries. Justice O'Connor's emphasis on the possible rather than necessary meanings of statutory terms does not reflect the structure of most dictionaries. At bottom, however, dictionaries provide alternative definitions so that the reader can choose among them based on contextual analysis. By asserting that her definition met the criteria of ordinary meaning simply because it was among the entries in 2 dictionaries, Justice O'Connor appears to have ignored this essential step of the analysis. This point was made cogently by none other than Justice Scalia, who, despite his usual predisposition towards reliance on dictionaries, dissented in Smith, claiming that the court does not appear to grasp the distinction between how a word can be used and how it ordinarily is used. Justice Scalia criticized the majority for selecting one possible meaning instead of identifying the way the statutory term will most likely be understood in context. Questioning the court's approach. The court's faith in dictionaries is problematic both from the perspective of statutory interpretation and from the viewpoint of linguistics. In the abstract, the association of dictionaries with ordinary meaning makes sense. The goal of modern dictionaries is to present as accurately as possible the accepted current usages of words. Yet a number of factors, y'all see what that means, man. We just gonna skim through some of this. See, when you pull out scholaristic work like this, even scholars run from this. They don't want no smoke, they don't want no parts of this. Tell one of your best scholars to get up here and read. They ain't about to read this. They don't do this on their channel. That's why I say this gonna be the most powerful channel stream I make. Y'all want our people to get on YouTube and talk about each other and tear each other down. Like I hear these so-called scholars debating and doing all that, and it's like y'all get a it's like I think y'all got some type of homosexuality undercover deep down inside because y'all get turned on by dissing each other. Like that ain't cool. Y'all supposed to be working together, and the elders is doing it. That's why you got little young dudes hating on me and walking around with Moors hats. Like if I smack that Moors hat off your head, you ain't gonna be making no more videos trying to talk about me no more. Cause your wife gonna be like, damn, he just put you in your place, baby. And you gonna be looking like, yeah, so what? I thought he was one of them temple Moors. Nah, I'm not down with your temple, bro. Stop looking at me like you control what we doing over here. Ain't none of y'all niggas controlling nothing. Y'all niggas is sellouts anyway. You more like a moron, if you ask me. Niggas walking around with Moors hats, acting like they sovereigns. Like, y'all niggas ain't got no jurisdiction or none of that. Keep talking about this Noble Drew Ali. You ain't never even met Noble Drew Ali. But I respect him. But y'all need to get off his nuts. Like, I'm just keeping it real. You juggling around Noble Drew Ali nuts. They said a lot of them court cases y'all talking about, you ain't even can't do a marriage in the Moorish Science Temple of America. So what is y'all talking about? Hold on. Let's put the screen back on this. They said a lot of these Moorish Science temples, these dudes is telling you, yeah, Noble Drew Ali, go to the temple and nationalizing this. They said that they got certain cases. You go on my channel where the name is on this. We just read a case where they said dudes was trying to come in and say they got marriage certificates and the state wasn't recognizing it. They said you got to get a state license to get married. They said the affidavits the Moorish Science Temple was sending was fraudulent. So I ain't gonna diss the Moors. I ain't dissing. I'm just saying that's what I read, and it was a federal case law, Supreme Court case. You got to prove that y'all getting case dismissed because nationality and lack of jurisdiction. And I'm talking to Sabir and all of them. I heard Sabir try to call out Hassan too. He talking about Hassan is clout chasing, doing clickbait and all that. You mentioning it mean you want more attention too. That's what that's saying. Y'all niggas is whack, man. That nigga said, Hassan, you could share this to Hassan Campbell too. That's what that nigga Samir said in his stream yesterday. I be watching these dudes, but I'm like, damn, they got envy. He mad because he watching Hassan views. That nigga shooting through the roof. He got like 200,000 views in one day. That nigga Sabir like, damn, only if I could promote and get on that level. You need to just ask him for help. But let's go. That nigga Sabir said, yeah, Hassan over there doing clickbait. How you know what he doing? How you know that ain't his way he teaching? He teaching the best way he know how. Let him do what he do. It ain't like you want to debate him on BAM or none of that. So, like, what's good? Like, come on, man, let's go. Dictionaries and convertism. We ain't even gonna get into that. Let's go. Like, it's a In the year the court decided Lochner versus New York, other commentators have suggested technical and substantive parallels between the Lochner court's effort to restrict government regulation of private transactions and the current court's revanchist conversation. Although the data set may be too small to allow for firm conclusions, it is intriguing that the only two instances of substantially increased dictionary citation have coincided with periods of conservative control over the court. We want to go deep into this, man. This is a long document. Dictionaries are not only vehicles of particular judicial programs, but also windows on language itself. The process of divining statutory meaning necessarily implicates linguistic concepts, and the value of dictionaries to interpretation must be judged in part on their ability to reflect the complexities of language. The court's use of dictionaries is problematic in linguistic terms for much the same reasons that the practice causes difficulties from the perspective of statutory interpretation. Dictionaries are forced to carry far more weight than they were or could be designed to bear. Failure to capture statutory context. Y'all screenshot this, and because when you could play this back, when you on the playback, you could pause certain parts of the video and you could read the whole clip. So we ain't got to keep it all the way up and read it all. That's why I'm just going through it a lot. It's a long document. One thing I don't like about a lot of these content creators, like y'all make channels and y'all don't go back and support the people who helped you out when you was coming up and they helped you get where you at. You don't know who helped you and did what for you. So they get on top and just think they got there all on their own. Like everybody ain't share your videos and support you. Even the haters like me, like, damn, can I get a fucking can I get a leather jacket? I mean, not leather. I want one with the fur, nigga. Even the haters, if you think I'm a hater, can I get a jacket with the fur too? I put you on. Helped a lot of y'all dudes get y'all views up. Whether I made diss records, videos criticizing, or whatever, all that helped. That's why y'all don't want to make diss records on me or videos on me, because you know all your people gonna come to my channel and get liberated. I'm a WEB to voice you niggas. And that's what they scared. J.A. Roger, you little niggas. They scared of the knowledge. When you pull out this, everybody gonna start running. All you gotta do is pull out some knowledge if you wanna get shake devils off you. If you see people's running around saying they on demon time and this and that, or they King Von ain't got shit on me and FBG Duck ain't got shit on me, tell them to pull out some dictionaries and read. Them niggas gonna run. You gonna see the Holy Ghost coming up out of them niggas. But let's go. These are all of the dictionary cited. Take a screenshot and look through some of them. It's a lot of dictionaries. They got Bouvier's 4th edition, Black's 1891. What's that? Black's Law 6th edition, 1990. Black's 5th edition, 1979. This the Pocket Dictionary. It don't say 1989 though. 1996. Let's say 1996. Let's say 1979. Oh, they got different editions that came out in different. I don't know. All right. I did a video called Attorney License Fraud on my other channel. Y'all could go check that out. That was a deep one over there too. Attorney License Fraud. And I'll pull it up for y'all. He said though all of these attorneys, they're down with a code called the Black Robe Code, and they're like a gang cartel and stuff like that. Look it up. Attorney license is fraud, right? There's no such thing as an attorney license to practice law. You know what that means? That means all these people y'all running around calling attorneys, they frauds. There's no such thing as an attorney license to practice law. So that means y'all a gang. The United States Supreme Court held long ago that the practice of law cannot be licensed by any state/state. You see the spelling? This was so stated in a case named Schwer versus Board of Examiners and is located for all to read at the following pages in volume 353 of the United States Reports, U.S. pages 238 and 239 of the United States Report. They say a state cannot exclude a person from the practice of law or from any other occupation in a manner or for reasons that contravene the due process or equal protection clause of the 14th Amendment. Even in applying permissible standards, officers of a state cannot exclude an applicant when there is no basis for their finding that he fails to meet these standards or when their action is invidiously discriminatory. It say the practice of law is an occupation of common right. It say they got a certificate. Look, where some confusion may start is when one doesn't understand that a state Supreme Court only issues a certificate, and that is not a license. All a certificate does is authorize one of those dirtbags to practice law in courts. To practice law in courts as a member of the state judicial branch of government. Please see note 1 below to see that there is no judicial branch of government as we have been led to believe all our lives. A plain truth of fact is that attorneys are foreign agents, the same as federal agents, from the bowels of hell known as Washington, D.C., and can only represent wards of the court, infants, and persons of unsound mind. The reader will be surprised to find out that according to them, we're all of unsound mind. That is, we're considered incompetent to handle our own affairs. Please see note 2 below for a reference in the law dictionary which explains this concept. Further, as a certificate is not a license, it also gives no power to anyone to practice law as an occupation, nor to do business as a law firm. The State Bar Association is not a government entity. The State Bar Association is professional association, and their state bar card is not a license either. All that card is a union dues card, like the Actors Union, Painters Union, Electricians Union, etc. Did the reader know that there is no Go bring me all your attorneys. Tell them to pull out some documents to debunk this. Case laws, motherfucker. I don't want to hear you talk. Just pull out case laws and just keep throwing them in the chat. That's it. Don't talk. Drop links. Give me all your lawyers. Bring all your lawyers. Tell them, come on. I don't want to debate. Drop the facts. You could leave a comment full of case laws saying you ain't got to practice. You stop lying. Y'all motherfuckers is frauds and pedophiles on top of that. You took the oath to the Masons, though. I know that. All y'all. That's why they particular pick who they want to be in the bar. You got to be a Mason. Or they going to put you in, and if you don't want to get in, they going to kill you. The State Bar Association is not a government entity. The State Bar Association and their state bar card is not a license either. That card is a union dues card, like the Actors Union, the Painters Union, Electricians Union, etc. Did the reader know that there is no other association, not even doctors, who issue their own license? All other licenses are issued by the state or local municipal corporations. Anyone can ask their state attorney general if the members of the bar are licensed by the state or any other governmental agency. The reader will find out in short order that the state doesn't issue licenses for attorneys, and that said attorneys are non-governmental private association. Therefore, by reason and logic and common sense, we can arrive. Y'all niggas is gonna get crucified with the truth. You come on this channel, we ain't playing. I know you ducking and dodging. Yeah, y'all ain't got nothing to say. Therefore, by reason and logic, common sense, we can arrive at a determination that the State Bar Association is an unconstitutional monopoly and thus an illegal and criminal enterprise, since the majority, if not all, of government offices are filled with attorneys. There's a definite violation of the separation of powers clause of a constitutional government. Attorneys are nothing less than foreign agents on our land, as they are foreign to a constitutional government. They have no power or authority for joining of legislative, judicial, or executive branches of a constitutional government, no matter if the so-called people vote for them. It is against a Republican form of constitutional government law for them to even attempt to run for office. Of course, this would include all judges as well as members of the other branches of a constitutional government. Y'all know what this means, right? Huh? I know that's a tough pill to swallow. You might have a headache after watching this video. My Cash App, $ Devon Bay, by the way. Don't run out of here, because I told you this is going to be the realest video we ever made. You thought I was playing, right? Note 1. In the municipal government, which is what all states, once called union states, are today, in municipal corporation law, there is no judicial branch. The judges, which we see today and which we've seen all our lives, are administrative law judges appointed by the CEO of the executive branch. Bring any judge in here and tell me I'm lying. Some other time, be and offer my conclusions, including the references which I use to make. You're not even a judge. I don't even know why I'm saying that. You an administrator. Like, I use to make said conclusion a little hint, if one could just understand how a W-4, which is of no lawful effect after 1 year, has its continued effect on someone who does not disclaim its effect, but instead allows the effect to continue for as long as that person is employed with the federal employee he filed it with. The relate that the same effect to the effect that the birth certificate has to one's continued effect of being incompetent to handle your own affairs, even if you're 67 years old, like this old goat. Note 2, see Corpus Juris Secundum, Volume 7, Section 4. Writer's note. We are all a product of our past experiences and teachings, and with those experiences, he giving thanks to his peoples. Did we go through that? Now we could go through this. Look, just real quick. No other association, even doctors, issue their own license. They are issued by the state. It is a non-governmental private. All are issued by the state. It is a non-governmental private association. See Attorney General Dan Morell's letter. As per this letter, the state does not issue licenses, and they are not issued by his office. The state bar is an unconstitutional monopoly. Article 1, Section 26, Texas Bill of Rights. An illegal and criminal enterprise violates Article 2, Section 1, Separation of Powers Clause of the Constitution. All right, we're going to go right into it, right? They are all monopolistic bar members in violation of the right to work laws of Texas. State bar rules at Article 3, Section 2, enrollment in the state bar. Each person who becomes licensed to practice law is required to enroll in the state bar within 10 days before or after receiving a license to practice law. Enrollment in the bar and license are not the same. The bar cannot license anyone. It is quite simple to see that a great fraud and conspiracy has been perpetrated on the people of Texas and America. The American Bar is an offshoot from London Lawyers Guild and was established by people with treasonous goals in mind. They have accomplished 98% of their goals. The New World Order is in the saddle now. American people start the job for them, or before their New World Order bosses, the international bankers, gain the remaining 2%. Texas and American lawyers should check historical records. They will find that the first people eliminated in the power shift, no matter who whines, are the lawyers and judges, for they always have proven themselves unworthy of any trust from either side. Woe unto you, or woe is a curse. Lawyers, for you have taken away the key of knowledge. You entered not in yourselves, and them that were entering, and you hindered. Luke 11:52. The American Bar Association traitors in our midst. The founding fathers who wrote our Constitution and formed our government made it very clear that this was to be a free enterprise country, and all citizens are to be equal under law and not a private capitalistic monopoly or cartel as they had experienced in Europe. Under free enterprise system, any citizen who was willing to risk his time and finances can go into business. The public with the freedom of choice can patronize this business or decide they don't like the service or product and stay away. Whereas in a private or capitalistic system, only the privileged elite can go into certain businesses or professions, such as have been practiced in Europe for ages, making the public their captive consumers or captive customers. I probably said it right the first time, right? The European bankers and financial cartels decided to change America to the same system that they had so they could take over this government too, and sent some British lawyers over here to organize an American Bar Association on the same order as the English bar, where only lords can be judges and determine who shall practice law. In 1909, they incorporated this traitorous group in the state of Illinois and had the state legislature, which was under the control of lawyers, pass an unconstitutional law that only members of this powerful union of lawyers called the American Bar Association could practice law and hold all key positions in law enforcement in the making of laws. At that time, Illinois became an outlaw state. and for all practical purposes, they seceded from the United States of America. The Bar Association then sent organizers to all the other states to explain to the lawyers there how much more profitable and secure it would be for them as lawyers to join this union and be protected by its bylaws and canons. They issued to the lawyers in each state a charter from the Illinois organization. California joined in 1927. In a few reluctant states and their lawyers waited until the 1930s to join, when the Treasonous Act became de facto and the citizens became captives. Under the system, the lawyers could guarantee prejudged decisions for the privileged class against the lower class. This was all made possible by the American Bar Association to favor the right and have unlawfully substituted them in place of constitutional laws. What is the real difference between the dreaded Klansmen in white robes and fairy crosses and the American Bar Association Klansman in the black robes sitting on the bench? Aren't they as dictatorial as the KGB and Gestapo are accused of being? This has fulfilled Orwell's prediction for 1984 and made it effect. The black robe coat. Various groups that have been lawfully stonewalled by the American Bar Association in the courts suggest we join hands and file an initiative to abolish the Bar Association, as there are 17 states where citizens have the right to do this by the voting process. If we can do this, it will destroy the power of the bar in America with similar method they use to gain their power, state by state. Any citizens who live in one of these 17 states can do this. And if not in one of these states, you can contribute to other states that can. Who is going to run the courts and practice law if we outlaw the bar? The constitutional common law courts and common law non-union counselors. I would like to remind you that the Constitution was written in plain English, and the statutes passed by Congress were also in plain English, with the intent of Congress how each law should be used and not the opinions of various judges as the codes list. Any normal person can read the Constitution and statutes and understand them without any trouble. The public in California was shocked to learn that the state government has no control or jurisdiction over the Bar Association or its members. The state does not accredit the law schools or hold bar examinations. They do not issue state licenses to lawyers. The Bar Association accredits all the law schools, hold their private examinations, and selects the students they will accept in their organization and issues them so-called license, but keeps the fees for themselves. So they select the students they will accept. If you don't throw up the right Masonic signs, you might not get up in there. I'm just saying. The bar is the only one that can punish or disbar a lawyer. They also select the lawyers that they consider qualified for judgeships and various other offices in the state. Only the Bar Association or their designated committees can remove any of these lawyers from public office. The state legislature would not change this system, as they are also a designated committee of the bar. On August 21st, 1984, Rose Bird, Chief Justice of the California State Supreme Court, another of the Bar Association's judicial committees, stated in essence that the bar should determine the legality of all initiatives before they were allowed to go on the ballot. This is contrary to both state and federal constitutions, as well as the laws of this nation instituted by and for the people as a sovereign unity of independent states of we the people, not a fraudulent corporate entity of lawyers. This is a tremendous amount of power for a private union that is incorporated and headquartered in Illinois to hold over the citizens of California or any other state. The only recourse is through this initiative process and vote by the people. After the founding fathers had formed the Constitution outlining the laws as to the way our government was to be run, Thomas Jefferson said in essence, This proves that plain people, if given a chance, can enact laws and run a government as well as or better than royalty. In the blue bloods of Europe, the American people must stop thinking that lawyers are better than they are and can do a better job than they can before the courts of America. Under the common law and the laws of America, nowhere is it expressly given for anyone to have the power or the right to form a corporation. Corporations are given birth because of ignorance on the part of the American people and are operating under implied consent and power, which they have usurped and otherwise stolen from the people. By right and law, they have no power, authority, or jurisdiction, and must be put out of business by the good citizens of America in their fight for freedom. We cannot hope to reclaim our country if we continue to let that beast stay in our bed and in our homes. It is imperative that we remove this demon from its throne and put our constitutional common law courts and justice system back into effect. We must stop worrying about what someone else will think. This is our country, and we have foreign entities attempting to take control of us and our nation. These children of Satan have nothing good in store for any of us. And those who are ignorant enough to believe their lies, deceit, and conspiracy deserve just what they receive because they asked for it. Bow! Most lawyers are our enemy. The small handful that are good must get on the right side and help us win our war. Or they are not on our side. There can be no more sitting on the fence. People must decide which side they are on and fight, Artie. Lawyers that claim to be on our side and are later found out to be traitors, Joe Pomelo, must be put to death, as this is just what they have planned for all Americans who do not abide by their rules and regulations. Americans cannot win the war if they allow traitors to infiltrate our tanks and get away with it. The enemy Americans are fighting is a deadly enemy that care nothing for anyone out of their own ranks. And if you turn your back on them, you could be their next victim. Treason. Lawyer and lawyer judge courts are unconstitutional. Since the biggest crimes in the world are committed in the courtrooms by lawyers and lawyer judges against the people, as the lawyers and their bar associations, which are affiliated with each other internationally, have joined in the international conspiracy against the people of the United States of America to destroy the United States of America from within. Can somebody spell treason? They have already taken over the courts and the government and all political parties, where they all take orders or oaths from one front office, the offices of the internationally affiliated bar associations. Make a one-party system, the Bar Association Party. This necessitated an urgent need to form a second political party, the Anti-Lawyer Party, where all lawyers and those who attended law school are barred from this second party. All the states have unconstitutional aristocratic courts, as their constitutions and or unconstitutional lawyer systems require judges to be lawyers, creating a ruling class which is forbidden by Article IV, Section 4 of the U.S. Constitution, the 13th Amendment, and Article I, Section 26 of the Texas Constitution. The U.S. Constitution guarantees to every state in this union a Republican form of government. Any other form of government is forbidden. No public officer or branch of government can be limited to a ruling class of any kind, or the states become aristocracies and not republics. Also, the lawyers have made themselves first-class citizens, where many public offices and branches of government are open to lawyers only. All other people are limited to only two branches of government and to only certain offices in those two branches of government, making all people who are non-lawyers into second-class subject citizens. When the courts belong to the people, as the United States Constitution requires, Article IV, Section 4, we the people will never rule against ourselves, or we the people will never rule against themselves. In these unconstitutional courts, foreign tribunals, or hoodlum centers, or human trafficking Human trafficking, auctioning blocks, men in black dresses that are unconstitutional, robes of nobility, Article 1, Section 9 and 10, with a lot of hanky panky and hocus pocus, winky dink, dispense a perverted ideology where the people are terrorized by members of the Black Robe Coat and lawyers and judges like Joe Palmetto and Artie in the courtrooms. The legislative branch of government does not have the constitutional power to issue court orders or any other kind of orders. Only presidents and governors have the constitutional power to grant pardons, but lawyers and lawyer judges are unconstitutionally granting pardons with immunity from prosecution. Citizens are not permitted to act like people in the courts. The citizen, second class, is told that he does not know how to fill out fancy lawyer forms, that he is not trained in the law, and that he does not know court rules and procedures, etc. This is unconstitutional. Lawyer system. Only hearsay substitute lawyers, not under oath, have access to the courts, even though only sworn testimony and evidence can be presented in court. Anything else is bill of attainder, not permitted under U.S. Constitution, Article 1, Sections 9 and 10. The U.S. Constitution does not give anyone the right to a lawyer or the right to counsel or the right to any other hearsay substitute. The Sixth Amendment is very specific that the accused only has the right to the assistance of counsel, and this assistance of counsel can be anyone the accused chooses without limitation. Lawyers and lawyer judges created unconstitutional lawyer system, pretrial motions and hearings to have eternal extortionistic litigations, which is barratry and also is in violation of the U.S. Constitution in Article 1, Section 14 of the Texas Constitution, as this places defendants in double jeopardy 100 times over. Defendants only have a right to a trial, not trials. When a criminal is freed on a technicality, he is freed because of a fix and a payoff, as a defendant can only be freed if found innocent by a jury, not by any technicality. Whenever a lawyer is involved in a case directly or indirectly as a litigant or assistant in counsel, all lawyer judges have to disqualify themselves, as there cannot be a constitutional trial. And also, there will be a violation of the conflict of interest laws, along with the violation of separation of powers and checks and balances, because officers of the court are on both sides of the bench. These same lawyer judges are awarding and approving lawyer fees directly or indirectly amounting to billions of dollars annually, all in violation of conflict of interest laws. Since crime and treason are against the law and the lawyer profession is a crooked profession, a legal bounty should be placed on all lawyers or betrayers and all those who are aiding and abetting these traitors and lawyers. The lawyers, these traitors, the lawyers. As long as there are lawyers, there will never be any law, constitution, or justice. There will only be mob rule, ruled by a mob of lawyers, traitors. Case law is unconstitutional, as case law is enacted by the judicial branch of government. When a lawyer judge instructs, directs, or give orders to a jury, the lawyer judge is tampering with the jury. He also tampers with testimony when he orders the answers to be either yes or no. The lawyer judge also tampers, fixes, and rigs the trial when he orders anything stricken from the record or when he rules certain evidence in the truth to be inadmissible. This makes the trial and transcript fixed and rigged because the jury does not hear the real truth and all the facts. Juries are made into puppets by the lawyers and the lawyer judges. All lawyers are automatically in the judicial branch of government as they have the unconstitutional title of nobility, Article 1, Section 9 and 10, officer of the court. Citizens have to be elected or hired to be in any branch of government, but non-lawyer citizens are limited to only 2 of the 3 branches of government. Lawyers, as first-class citizens, can be hired or elected to any of the three branches of government. Lawyers, officers of the court, and the judicial branch are unconstitutionally in two branches of government at the same time. Whenever they are hired or elected to the executive or legislative branches, this is a violation of the separation of powers, checks and balances, and the conflict of interest laws. District attorneys and state attorneys have taken over the grand juries from the people, where the people are denied access to the grand juries when they attempt to present evidence of crimes committed in the courtrooms by lawyers and lawyer judges. Try taking this material to the grand juries. The U.S. Constitution, being the supreme fundamental law, is not and cannot be ambiguous as to be interpreted, or it would be a worthless piece of paper, and we would have millions of interpretations, unconstitutional amendments, instead of the few we have now. That is why all judges and public servants are sworn to support the U.S. Constitution, not interpret it. Imagine hypothetically how stupid it would be if any constitution stated that the judicial branch of government has the power to interpret this constitution. Organized crime never existed until the Bar Association took over our courts and our government. Now crime is organized internationally, just as the bar associations are organized. Some of their international affiliations include, but are not limited to, the International Judicial Association, International Trial Lawyers Association, World Peace Through Law Center, World Assembly of Judges, et al. This means that the bar associations are not only the International Crime Syndicate, but also the International World Government and International Communist Party. Under international orders, all lawyers, whether they left law school yesterday or 50 years ago, are exactly the same. All lawyers have to file the same motions and follow the same procedures and using the same unconstitutional lawyer system of winky dink, hanky pank, and hocus pocus, and to destroy the United States of America from within by always ruling against the people. All lawyers and lawyer judges are guilty of treason. In probate, the lawyers place themselves in everyone's will in a state. When they are minor children as heirs, the lawyer judges appoint a lawyer, a child molesting faggot, for each child, and at times the lawyer fees exceed the total amount of the estate. An outrageous amount of tax money is directly and indirectly stolen by lawyers, money that is budgeted to county boards, school boards, and other local and federal agencies eventually finds its way into the pockets of lawyers, as all of these agencies are tricked and forced into eternal extortionistic litigation. In all elections, vote against all lawyers. Never vote for a lawyer. Vote for non-lawyers only. If only lawyers are running for election to the same office, do not vote for any of them, as most are all alike. All lawyers are programmed to be traitors and inhumane clones and pedophiles. Walk softly, Americans, and carry a big rah. Most importantly, don't be afraid to use it. We are under vicious assault, and we must make use of every recourse or resource we have, or given to their slavery. Copy and spread widely. Send copies to the criminal lawyers and lawyer judges. 2 Corinthians 5:5. For we walk by faith, not by sight. It say walk softly, Americans, and carry a big bow. That's what that say. I ain't say it. Y'all hit that like button. Share this video out. Hit the Cash App, $ Devon Bay. Peace and love. Peace.